Hello everybody, this is Chris Addig with the Veterans Law Blog. It is Friday, December the 9th, 2016, and I believe we are live right now. So in any event, there is a little bit of a delay right now, so I apologize. I'm going to wait for this little lag to catch up, and then we will go ahead and get started. So going to jump right in, starting a little bit later than normal today, starting at 4. There's something I want to show you. Hopefully the sun will go down in time for me to show this to you, so I tried to schedule this. Hopefully we'll catch a few more people here by doing this at 4 p.m. Central. We might catch a few more folks getting off work on the East Coast. If you guys have a suggestion on a better time to do this, let me know. In any event, this video will be recorded as we're talking here, and then it will be put on the Veterans Law Blog site on Monday, so that if you're not a Facebook member, Facebook follower, if you're not able to stick around for the whole thing, you can come on the Veterans Law Blog and watch it there. So let me tell you about the Veterans Law Blog real quick, and then we'll jump into today's live question and answer session. So the Veterans Law Blog has been around since 2007. It started initially while I was doing my own VA claim. I served in the Army from 1993 to 2004. And while doing my own VA claim, I realized there's just not a lot of information out there. At the time I filed my claim, I was an attorney, and so you would think that I would have some ability to understand these complex processes, and this one was way over my head. I ain't a dumb guy. I clerked at the Texas Supreme Court while I was in law school. Well, I guess I worked for the Department of Treasury, so maybe that wasn't too smart. But in any event, I couldn't figure out the VA claims process. I couldn't make heads or tails of it, and there was not a lot of resources out there to do it. So I started, as I learned this process in my own claim, I started with working with some vets through an email listserv. They began to have success in their claims, and so started publishing a blog. That blog started getting out to more and more veterans who were asking for more in-depth information, and so I started writing some ebooks. And those ebooks went into a lot greater detail than we did on the blog, and veterans like yourself probably were asking for a lot more information, so we started recording training videos and courses. That brings us to where we are today. Literally hundreds of thousands of veterans are on the Veterans Law Blog site at some point each month. I think we're up to 67,000 followers here on Facebook, which is a pretty substantial number. I had no idea that it was going to get this big. And one of the downsides to getting this big and helping so many veterans is the cost. It certainly costs a lot of money to host video. It certainly costs a lot of money to make this video permanently available, to host all the content, thousands of blog posts, thousands of not thousands of books, but about a dozen or so books and several hours of training videos. It costs some money to do that, as well as to make it readily accessible to y'all. So at this point, the Veterans Law Blog is member supported. There are memberships available on the blog. I'll put the link in the show notes. I'll tell you about that in a minute. I'll put the link in the show notes where you can learn about monthly and annual memberships to the Veterans Law Blog. And so when you join, here's what you're going to get. You're going to get access to thousands of posts on every topic imaginable. There are still quite a few topics we haven't written anything about. So I try to provide topics that are responsive to what veterans are telling me they need, whether it be about service connecting a particular condition, a claims process, whether it be about a particular level of the claims process, or how to file a form, or how to fill something out. All that information is there. There's hours of video training, from teaching you how to file your own fully developed claim and get it right the first time, to getting your C-file. There's training to getting 5-star evidence. We've got training on that. We've got training videos teaching you how to write more persuasively in your VA claim. And as a premium member, you're also going to get 15% discount on any purchase of any ebook or training video that's available. And you will get priority customer support and questions and answers as available on the blog. So if you ever do need support, look for the little green button in the lower right corner of every blog page. It says support. Click on it. Make sure you read through some of those answers first, see if some of them answer your questions, and then submit a support ticket if not, and I will respond. I try to get to the premium members as quickly as possible. Also, premium members get an opportunity to participate for free in webinars. We're having a webinar come up next week, and we're going to do them monthly after this. The first webinar is how to get and use your VA claims file. We're going to spend 90 minutes on December 16th talking about that. And premium members got early bird opportunities to get in for free. So you'll have that as a premium member as well. All those links will be in the show notes. So if you know of a business or company that is interested in reaching and talking to veterans, let me know. We certainly are interested in having a couple of those businesses come on and advertise to veterans. It will help us to offset some of the costs and keep the membership prices down low for both the monthly and annual. I've gotten word one of our vendors has significantly increased their prices, and so I'm trying to avoid having to raise prices on the annual subscriptions, but I think I'm going to have to come January. So I'm not going to do it without letting you all know that. And I don't think it's going to be a significant increase. Of course, it is likely to go up. I'll talk more about that later. But ads are available either in this video or, as you'll see, in the podcast that we're releasing next year. We can have pre-roll, mid-roll, end-roll ads, and we can also have run-a-site ads on the blog. If you know a company that's interested, have them watch this video or have them reach out to me at support@veteranslawblog.org. Okay, so enough with all the membership there. I'm starting to sound like NPR or something, kind of. I got to get it out of the way, though, because we got to pay the bills and keep things running if we want this service to be available. And thank you all for joining as a member, as a premium member. You are really helping to get word out to veterans and survivors of veterans that are filing claims with the VA. So, how does this work? This is a live cast. We're in episode number 7. And we do this every Friday afternoon, usually about 3 o'clock. Today we're starting a little bit late, but in any event, it's structured like this. So the first part, we're going to go through some news and some announcements about stuff that's going on in the veterans community, particularly those things that affect veterans in their benefits type claims and health type claims and those sorts of issues. Then we will go into the main topic where I'm going to spend about 10 to 15, maybe as long as 20 minutes, talking about a particular issue in the VA claims process, in the law of VA claims, something that I think will reach a lot of members, will reach a lot of people and help a lot of people. And I'll go into depth on that. For example, last week we did a talk about how to get and use your C-file, started talking about what the C-file is, what makes it different from medical records, what you can use it for, why you want to have it, all that sort of stuff. We kind of went into a lot of detail on that. Another time we went into detail on 5-star evidence. So today, I'll tell you what the main topic is coming up. But after that main topic, we're going to go and answer your questions. So if you want me to consider your questions, go to veteranslawblog.org/Facebook Live, and a form will come up. You can submit your question to me there. I do read every question, and I try to look for ones that there are a lot of questions or a lot of folks asking the same question so that I can cover the most information possible. So we've got 3 really awesome questions coming today. And then when all of that is done, for those that stick with me through the whole video, or those of you that come back and watch this later after the fact, I'm going to offer some coupon codes to you so that you can get discounts in the coming week on the veteranslawblog.org. So, in any event, after this video is over, I'm going to post what I call show notes. I will post those in the very first comment below this video. On Monday, well, actually it'll be Tuesday this week, and I'll tell you about that in a minute. But on Tuesday, this video will appear on the Veterans Law Blog website, and below the video will be all the different links to whether I mention a news article, if I mention a book, if I mention a blog post. It is going to be on that web page. So, in any event, I just got a message that the recording of this is giving me a problem. So we may have to stop the recording at some point. But in any event, it's not going to affect the live broadcast other than distracting my attention. So in any event, the show notes will be available after the show, and then they will be there permanently. I do put this video on YouTube as well. However, YouTube does not allow me to put the links to all the show notes in their notes section. I've gone round and round with them, and they just don't want all the links in their comment section on a video. So if you see this on YouTube, that's why there are no show notes. You got to come to the veteranslawblog.org. Or you've got to hop on Facebook and click on our video tab, and all these videos, as well as all the videos that I've done over the past 3 or 4 years, are on our video tab. So, enough familiarization there. If you have questions, hop on the Veterans Law Blog, look for that green support button, and submit a support ticket. See if those questions are answered in our help desk menu first, though. All right, so moving on to the news this week. Kind of a slow news week. Typically this time of year is, for a couple of reasons. First of all, this is getting into use or lose leave situation for federal employees. So they've got a lot of leave. A lot of senior employees build up their time off to the end of the year and take off 2 or 3 weeks. So not a lot of stuff happens in the VA, at least certainly not at the levels of claim processing that involves senior employees. Most of them are taking the time off. Not seeing a lot of stuff come out of the board for similar reasons, and also because they're doing some end-of-year type stuff there as well. The court is kicking out the regular amount of decisions. Nothing significant to report there, although I have a couple cases I want to talk to you about next week. But another reason it's slow is because Congress, who's going to pass the bills that change this process, that affect this process, that affect your claims and health benefits, Congress is going to adjourn their session December 16th. So what is coming out of the Hill is kind of, it's political stuff, what they're doing, as stories are being planted about this bill being pushed, this bill being passed, or adding this amendment. Everybody's jockeying for some sort of leverage in the last few days of the Congress. So we've heard everything in terms of rumors about appeals backlog stuff going through, about veterans' choice reform legislation going through, or as some of you know that I call it, the Veterans No Choice legislation. So we've heard all those different things. Nothing real clear is coming through the fog, so to speak. And some of the top folks at the VA have suggested that they are not expecting to see any significant litigation passed. That said, we never know. Let's stay tuned. Next Friday, December 16th, is the last day of the session, so there's likely to be some activity. One area where there's a lot of rumors is this new VA secretary position that's out there. So at the end of this current administration, Mr. McDonald will most likely be asked to tender his resignation as the Secretary of the VA. There's good and bad to that. I personally think he's been one of the more transparent VA secretaries that we've ever had, and he's done a lot of things. I think there are a lot of places where he could have done better, but because of that transparency that's just much more significant than we've ever seen out of any VA secretary, I am going to be sad to see him go. Hopefully the person that comes in to fill his shoes follows his lead in terms of transparency and accessibility of the senior levels of the VA. Many of you have seen and remember Allison Hickey. She was instrumental in kicking a lot of cases that had fallen kind of by the wayside. And the last year that she was in her position before she resigned, she was very instrumental in helping to kick a lot of these cases back open and get veterans benefits when they thought that their claim was dead. So hopefully that sort of stuff continues. But we don't know who the replacement is going to be. A couple weeks ago, we talked about the possibility of it being the current, soon-to-be former House Veteran Affairs Committee Chair, Jeff Miller. Some of the pros and cons we talked about. One of the other names that's being floated is Sarah Palin, and while I've got nothing against Ms. Palin, I just don't understand how she would have the experience or knowledge when it comes to veterans issues. But that said, I'm not entirely convinced that that's a real serious name that's being floated. It's one of those things that's being talked about. One of the other more serious names is an individual named Pete Hegseth, who is, and I think I'm pronouncing that correctly, but he is himself an Afghanistan veteran. I believe he was a major. When he got out, he worked on the Concerned Veterans for America Foundation, CVA, some of you know it as, which is for lack of a better word, it's a group that's trying to push some reforms, some pretty significant reforms through the VHA, mostly the VHA, a couple on the benefits side, but trying to reform that health administration. In some ways, privatize small pieces of it, in other ways, not so much. But in any event, he's very young, 36 years old. A lot of folks like him from this new generation of veterans. I'm not sure how serious the nomination is. I know that he's closely tied with the Koch brothers. And what role that has, I don't know. I'm just telling you what little bits I know about him. But in any event, if any of you know or have any experience with Mr. Hegseth, I'd love to hear about it and kind of see how that is going to impact his possible nomination as VA Secretary. We might know by next week, we might not. So stay tuned, and we'll see if any other names come up. Another thing I want to tell you guys about that did come out, for years and years and years, the Veterans Health Administration has rated each of their facilities internally, and a lot of folks have tried to get that information from the VA to start understanding what the VA thinks of its various facilities. And for years and years and years, they have told veterans, they have told the press, they have told all sorts of folks, frankly, even Congress, that this is for internal deliberation only, and they're not going to share this information. Their concern is that we wouldn't understand a 5-star rating system. I don't know. I really don't understand it. Frankly, open up government a little bit, let folks see what's going on. Private sector might have some solutions for you, VA. Who knows? But in any event, they kept it secret for all these years. USA Today published a piece, and the link will be in the show notes, talking about getting their hands on that internal documentation that shows and ranks each and every VA medical center on a 1 to 5-star basis through fourth quarter of 2015, and then I think compared to the rating through second quarter, I believe, of 2016. So it's very illuminating. You can search your own facility and see where it ranks. I was surprised by many of them. I have seen, for example, the Dallas VA Medical Center was for many, many, many years ranked as one of the worst in the system. And I got to see, when they got a new director come in, some changes being made, but they continue to have a 1-star rating. The Little Rock facility here in North Little Rock, Arkansas, is rated at a 2-star. And I think 3 of the places in Pennsylvania were consistently up in the 5-star area. So it gives you an idea. Again, for what they're worth, a 1 to 5-star rating doesn't tell you that very much. I mean, any of you guys that watch Netflix and look at the fried green tomatoes, I can't even talk about it, the tomato rating, whatever the heck that is, fried green tomatoes. I'd never watched that movie. I got roped into it. I'm never going to watch it again. Anyway, the tomato ranking thing that's up there, you can barely tell if it's green or red. The percentage, what does that mean? It's not until you get into the meat of the reviews that you understand if those are good movies or not. Same way with this 1 to 5-star rating, it really doesn't tell us a whole lot. Where it is good is you can get a sense of how your facility compares to other facilities that veterans might go to. And when you hear one veteran saying, I love my VA hospital, and another veteran saying, I would rather, go to somebody out on the street to perform surgery on me than to go to my VA facility, you can look at those and compare and understand why there might be such a disparity. But in any event, that'll be in the show notes. You can look at that USA Today piece and learn all about it. That said, I have one really awesome announcement for you guys that I'm going to put in the news section. In 2017, early 2017, we are going to launch a Veterans Law Blog podcast. We're recording shows right now, recording all sorts of stuff and getting everything all set up, all the technology. Hope to release it early in 2017. It's going to be totally free. It'll be on all the major podcast feeds. We'll host it on the blog itself if you want to view it on a website. But what I'm looking for from y'all is ideas about things that you want me to talk about in a podcast, things that you might want me to cover in terms of VA claims topics, folks you might like for me to interview. So what I've done is I've set up a survey. If you would go to veteranslawblog.org/podcast, veteranslawblog.org/podcast, and you can do a couple of things on that site. First of all, you can get there and click on the links to follow through to take a survey. It's a 10-question survey. And at the very end of it, I'm going to give you a special discount on a membership for your participation. And as a thank you for giving me that information and trying to help me understand how to make this podcast be the best resource that it can be for folks that like podcasts. And also you can go down and you can sign up for an email, and I'll keep you posted. I'll give you some behind the scenes shots and videos and talk to you about what to expect on the podcast. We'll hopefully a couple of our guests will agree to have their portions of their interviews released early so that you can hear those if you sign up for this email address. So in any event, sign up for it. Let me know what you think about the podcast idea. It'll be totally free, but it's just another way to reach more veterans and get more information to more veterans about battling the VA and getting through this claims process. I talk about a topic a lot on the Veterans Law Blog, and we're going to go into the main topic at this point. One of the things that I talk about a lot is the idea that you have more power at the VA than you think. That there is a way that you can have a better experience with the VA and that you can cut through the fog of the VA claims process. Okay? That very first step that you have to take in order to do that, the very first step is we have to have, as veterans, we have to have a change in mindset about the VA. I'm not saying we have to blow sunshine up our asses about the VA. We don't have to do any of that sort of nonsense, but we have to change the way that we think about the VA. And I'm not saying this stuff just as hype. This stuff actually works. I'd like, if you could bear with me a minute, I'd like to read you an email that I got from a veteran Tuesday morning. His name is Larry S., and I've known Larry on the Veterans Law blog for a good bit of time now. He's asked some really good questions privately, and I hope I've given him some answers. He served in Vietnam, and he also served in Thailand during the Vietnam War. And here's what he wrote. He said, Chris, I have a full membership and have many of the applicable volumes which covered many of my disorders, talking about his ebooks that he had purchased. Today I received notification that I won all of my claims and I'm now rated at 100%. He had conditions like sleep apnea, multiple myelomas, prostate cancer, ischemic heart disease, PTSD, diabetes, peripheral neuropathy, hearing loss, and tinnitus. He got those all service-connected, got them all rated, and he's at 100%. He said, with the help of your blog, I cut and edited my presentations. I eliminated non-essential data. I used documents in my C-file, and I came out a winner. Your step-by-step guides were very helpful. The volumes were worth every cent to the fourth power. I'm not a lawyer, and a VA rater once blew me off telling me that you don't have a case. Signed, Larry. So that sort of experience, I'm hearing more and more of those types of experiences from veterans. And I don't say that to tout the Veterans Law blog. It is what it is. You can get on there and see with a membership if it's right for you. Take 7 days free and look at it. That's not why I'm mentioning this. What I'm mentioning this for is to tell you that folks like Larry, folks like the other folks whose posts appear in Facebook and on the blog who've had success here, they all attest to the fact that they started out with a change in mindset. You can see that in the way Larry is written. He talked about cutting and editing his presentations. He talked about getting rid of non-essential data. All of that sort of stuff. He wasn't able to do that until he realized that he had more power over the VA than he thought. He realized that, had that realization, and the next steps of this process of improving a VA disability claim fell right into place for him. So let's talk a little bit about what that means, about how you get that power, how you change your experience with the VA without the VA having to change a darn thing. Okay? So let's start from the beginning. We are led to believe that we're powerless over the VA. We're led to believe that there's certain things that'll never happen, certain things that'll take forever, certain people that are trying to cheat us, certain things that are, going to be our lot in life to deal with as veterans. When dealing with the VA, we're led to believe those things. And I believe that it's kind of the consequence is that we're taught to live in a state of learned helplessness when it comes to the VA. For example, we perpetuate these myths, some of which I'm going to tell you about in a minute. But by perpetuating these myths about the VA claims process, pretty soon folks start believing them. So when we repeat things over and over and over, we start to believe them. They become our reality. They become self-serving, self-fulfilling prophecies. Some of them, were really bad in terms of building a prison, really, of these self-fulfilling prophecies. Let me tell you about one. If you believe that you have to just sit and wait for a decision, you're going to end up just sitting and waiting for a decision. If you believe your VSO is going to take care of you, chances are greater than not that you're going to let that VSO take care of you, and you're not going to find out that they were doing something wrong all along, like the one veteran we write about on the blog who got all the way up to the board before he found out in his C-file that his VSO, I believe it was a VFW rep, had told the VA not to acknowledge or pay attention to or give any credibility to the examiner who said his condition was service-connected. That veteran, in all likelihood, believed that the VSO was taking care of him, and as the myth goes, never followed up or wasn't able to follow up. If you believe that attorneys are in this process to suck your blood, steal all your money, give chunks of your claims, and do nothing, then they're going to do that. You are going to fulfill that reality, okay? Now, I know a lot of attorneys that do this work, and that's not entirely true, but I'm not getting into that myth. What I'm saying is that by believing and buying into these myths, we create the reality that fulfills them. And so if you want to break out of this prison that we've created with these myths that go all the way back. I mean, these are things that have been said about the VA claims process going back to World War II. And I know that because I've looked at World War II veterans and their survivors' claims files, and I've seen the same things over and over in the letters back then that they typed, sometimes hand wrote, and sent into the VA. It's the same thing over and over. So, when I look at all of these different situations, when I look at what veterans write in, when I look at what veterans tell me, when I see these things in the C-file, these patterns, I start to think and start to see that there are certain things that a veteran can do differently in their VA claim. They can have a tremendous impact on giving you power over the VA, giving you a better experience, and hopefully giving you a better outcome in your VA claim. Okay, now I've written a little ebook on those. It's available on the blog, and it's called The 5 Reasons That the VA Keeps Screwing Up Your Claim and How You Have the Power to Fix Them. You guys know by now that my titles are just horrible. I just say what it is. These are literal titles, and I don't have short ways of saying this. If you do, let me know, because that is a mouthful. But this ebook is available on the website. I'm going to talk you through some of this stuff generally. If you want more detail, you can go there. But the first thing that I would tell you that can make a major impact in how you experience the VA is changing this. A lot of veterans send the VA a haystack and then complain when the VA can't find the needle. What do I mean by that? I've requested hundreds of, possibly even thousands of claims files for veterans, and looking through them, some of them are 4, 5, 10, 12, 20,000 pages long. And when you look through it, there's all sorts of information that just doesn't need to be in there. Information that has no bearing on the claim. Information that's not related to any sort of issue of nexus or service connection. Information that doesn't really help or change or give any understanding to the rater about how that disability is affecting the veteran today. There's, comparatively speaking, very little of those 2, 4, 10, 12,000 pages are guides for the VA to walk them through your claim, to show them where the information is. That's what I call showing the VA the needle. If you show them the needle, they will use it. If you give them a haystack, they're going to dig through it, and there is no telling what they're going to find. Okay? The general rule of law is that when you're got a big stack of stuff and a big stack of work to do, you're going to try to get through as much as you can, as quickly as you can. The more complicated something is, the more likely somebody is to procrastinate on it. And so by not sending in a haystack full of evidence and not yelling at the VA when they can't find the needle in the haystack, and changing that behavior to give the VA the needle that they need, you're going to change the way you experience the VA claims process. You're going to have a more positive experience, and hopefully you're going to have a faster experience. Now, there's some claims that the VA is just going to fight tooth and nail on for years. They're just not going to give up on it. So, for example, if you are a Blue Water Navy vet and you are claiming exposure to Agent Orange, you better have an 8mm video of you kind of mixing up that tank with your hand for them to grant it, because they just fight on those cases. If you're looking for effective dates going back 20, 30 years, they are going to fight on those cases. Okay, for some reason, and I don't understand this, military sexual trauma and mental health conditions relating to them are claims that take a long time because the VA fights them. So when it comes to those, though, you can make your experience better ultimately in the appeals process by providing less but more clear information to the VA. And so what are these needles that I'm talking about? The first needle, I call them the 4 pillars of service connection claim. And the 4 pillars, we're going to talk about that next because that's the second issue. But we're going to talk about this 4 pillars concept. There's 4 things you need to prove in most VA service connection claims. Pillar 1, you need to prove you're an eligible veteran, right? The second one, you need to prove that you have a service-connected disability, a current diagnosis of an illness, condition, or disability that has some nexus to your military service. Then you need to show that that disability, and that's pillar 2. Pillar 3 is that that disability is impacting you today, all right, and you provide facts of that support this percentage that they're going to give. And then you have to be able to show that you actually filed a claim so that they can give you an effective date and grant past due. So those are the 4 pillars. Those are the 4 needles, if you will, right? Eligibility, service connection, impairment rating, and effective date. Those are the 4 needles that you really want to focus on. Okay, so when you're sending in information, focus first. And this is not to ignore pillars 3 and 4, but focus really hard on 1 and 2. Make sure that you show them that you're an eligible veteran. Most folks, that's just sending in your DD-214 and showing that you had a qualifying discharge. If you have a discharge that's not qualifying, you're going to want to go and get that upgraded before you file, and then file with the VA. But focus really hard on showing that service-connected piece there. And really all you have to do is show the needle of a current diagnosis of a disability, that something happened to you in military service, and then a bridge that covers those two things. There's 5 different bridges. I'm not going to get into it, but those are the needles that you're trying to show them. And if you give them only the evidence that they need to see to prove that particular element, right, you've given them the needle, and you haven't given them a haystack to look through. Okay, so that's the first thing that veterans can do to change their experience with the VA, is to give them the needle instead of giving them the haystack. Okay. The second thing, learning the VA's language. Okay, and this is challenging, right? Because there are so many different languages that the VA speaks, right? And depending on what level of the process you're at, the language that they speak might be different from another level. The concept of service connection is a perfect example of this, right? So we veterans, being real basic, easy to understand folks, believe that service connection means that our current disability is connected to our military service. That's all it means. Nothing big. When you get to the VA, they say that there are 3 elements, right? I say 4 pillars, they say 3 elements. That's all the way up to the board, which has their own concept of what it means to service connect. And then by the time you get to the Veterans Court, you're going to see that there's case law, but the Veterans Court that talks about the 5 elements of service connection. All right, so each level of the process, I'm not saying that it's adding different levels. What I am saying is that they're talking about the same 4 pillars in different ways at each stage of the process, and they use different language, right? So we've got to learn that language. You know, we've got to learn what it means to prove service connection. We have to learn what it means to prove that something is at least as likely as not related. We need to learn what the presumption of soundness means. We need to learn this language that they speak, which is foreign to most of us. Even those of us that practice law, some of this language is pretty mind-bogglingly complicated. It is not an accessible language, so you need to learn that. And once you can speak the VA's language, don't try to get them to speak yours. Don't try to do it. It doesn't matter. I was on the phone with a DRO a couple of weeks ago trying to get the DRO to understand something about a claim, to think kind of big picture about how long this claim had been open and pending. And they just kept coming back to the same paragraph in the M21, their rater's manual, and couldn't see beyond it because I wasn't speaking her language, right? She wanted me to speak her language. Her language wasn't really, getting to the meat of the issue in this case, even though I know I'm right when it comes to this case, but because I couldn't speak the language, we were at a crossways and didn't move any further. So learn to speak the VA's language. Spend some time. How do you learn that? Spend time on sites like hadit.com, a great site with some great message boards with a lot of veterans that have been practicing in a lot of VA claims and helping veterans in a lot of VA claims for a very long time. Teresa, one of their founders, or the founder, is an amazing, amazing veteran who's been compiling this stuff for over a decade. A fascinating person, outstanding site. Another one is, if you're into understanding some of the more esoteric pieces of the law, go to the Ask Nod blog. The links will be in the show notes. That's asknod.com, I believe. I don't actually remember what the URL is. Just look in the show notes. But in any event, he is somebody who has, as a Vietnam veteran himself, has learned a lot about the VA claims process. And Alex is a very smart individual, probably about 10 times as smart as me, frankly. And I'm not that smart, but he is smart. Getting into all sorts of confusing issues here. But in any event, if you read his blog, he has a real esoteric insight into how this works, and you can really learn some language from him. There's, the Veterans Law blog. Ben Krause has the Chapter 31 disabledveterans.org that goes into voc rehab, and he talks about that language a lot. So check out that site. Learn about this language. Get the M21 emails or links to them. You can go on the VA website. You can see the M21 manual online now, and you can read, for example, when you submit your VA Form 9, you can go on there and read what the VA rater is going to do when they get that VA Form 9. And you can use that to your advantage to put certain information in there to help them catch their eye, to get them to rethink something before they certify it to the board. So there's little tools, and that's where you learn this language. It's learned over time, just like anything else. You can, if you don't speak French, you can't parachute into Paris and expect to speak the language overnight, right? You're going to have to spend some time getting immersed in that culture, in that language. So do that with your VA claim. Spend a little bit of time. Learn things like credibility, right? That's another component of VA language. I call that the rabbit hole, because we veterans put a lot of value, and rightly so, on our integrity and our honesty, right? And I defy you to find me a veteran that does not believe that they are scrupulously honest about their situation when it comes to military service. That's just a character trait that's ingrained in us. I'm not saying we're all honest. You know, I mean, I lie to my kids to get them to do things all the time, right? Joke, if you're watching this, I never lie, ever. Always tell the truth. Point is, when a VA ratings decision or a Board of Veterans Appeals decision attacks a veteran's credibility, it sends you down a rabbit hole, because you think that they're saying you're not an honest person, that you're a liar. And legal credibility means something completely different. It talks about perception and ability to perceive events. It talks about bias on whether or not you have an interest in an outcome or an interest in a particular interpretation of a fact. It doesn't always mean, and it very rarely means, truth-telling ability. In fact, even when it talks about integrity, it's talking about the structural integrity of your facts as they relate to other facts, right? So when a board judge or a VA rater says that you lack credibility, a lot of veterans will spend days, weeks, months, years going after the VA to prove that they're honest, and it's a rabbit hole. They don't need to do that. They need to attack the underlying credibility finding, which is those three pieces: perception, bias, integrity. We'll talk about that another day. There's some posts in the show notes, but that's a rabbit hole. Another one is this whole concept of reconsideration. I'm going to put some links in the show notes, and I want you to read these posts. There's no such process as reconsideration at the VA ratings decision level. So a lot of folks are being told to file a reconsideration when they get denied for a VA ratings decision. The VA is sitting on it for a year, missing your nod or your appeal deadline, and then they're coming back and saying, oh, we're not going to reconsider it. So it's a trap, and it's a trick. But learning that when you hear the word reconsideration, there's only two places where you can actually get something reconsidered. You can file a request to have the board, the BVA's decision, reconsidered. There's posts on the blog about why you might or might not want to do that. And if you're at the Veterans Court, if you get a memorandum decision, you can ask the court to reconsider it if it's not favorable, or if you believe that that decision has an error in it. So there's no reconsideration, but it's a trick or a trap. And if you don't know this language that the VA speaks, you're not going to be able to spot that trick or trap, and you're going to be stuck in the VA claims process a lot longer than you have to be. Right? Okay, so that's the second thing that I think veterans can do better. The third thing is that we don't know what the VA knows about our claim, right? And I talked about this in another episode, talked about getting your C-file. And one of the important reasons of getting that C-file is to learn what the VA is looking at when they rate your claim, when they deny or grant service connection, when they grant you a non-compensable reason, when they deny TDIU, when they take any action in your claim or appeal. It's all based on what they see or do not see in your claims file. And even as many veterans that are getting their C-files out there, there are still many, many, many of you that aren't requesting your C-file or don't understand what the C-file is, and so you're getting medical records or you're getting military service records thinking that's your C-file, and it's not. There's this whole file out there that has all your claims documentation. The VA resists giving it to you. We talked about that in depth in another episode. I'm not going to repeat it here, but get your VA C-file. Get your darned VA C-file. Anybody seen Leslie Nielsen's Rules of Golf? This is one of my favorite shows. It's the last time I think I actually saw a copy of it, it was on a VHS. So that tells you how far back it goes. But Leslie Nielsen from Naked Gun and a couple other famous movies there talks about the 3 rules of golf, right? And I don't play golf. Actually, I did a long time ago, but I got so frustrated, spent more time, chasing down the clubs that I threw instead of, actually playing the game. But in any event, the 3 rules of golf are: keep your head down, keep your darn head down, keep your darn stupid head down, right? Okay, the same rules apply to VAC files. Get your VAC file. Get your darn VAC file. get your darn VA, I don't know what the third one is. I don't want to say the word stupid. But the point is, get your VAC file. It really is an essential thing to being able to understand why the VA is denying it, and you might be able to fix something quickly, or you might see that you're in it for the long haul, in which case you can take a step back and build your case for an eventual win at the board, rather than fighting over trying to win something you're not going to win at the regional office, okay? So that's the third thing. So we've talked about sending the VA needles instead of haystacks. We've talked about learning their language, right, so that we don't go down rabbit holes and fall into their tricks and traps. We've talked about getting their C file so we know what they know, and we're looking at the same facts as them, right? The next one, I'm going to tell you this is a tough one. There's just too much writing in most of your claims files. Too much. I will look through a claims file and I will see VA Form 2140-138. I'll see 25 copies with 17 pages attached to them, all telling the same story over and over and over again. And that's not to slight anybody. A lot of times we don't know what to give the VA, and so we do that sort of thing. But the point is, you only need to write so much, and you only need to write it in a certain way, right? So think of it this way. If you are sitting down and somebody's asking you to do something, and they give you 20 pieces of paper, and it's all handwritten and really difficult to read print or cursive handwriting, some people, believe it or not, cannot read cursive, and that's fine. But if you write something in cursive and it goes into the VA and you get one of those raters that can't read cursive, it's wasting your time. But imagine yourself getting 20 pages of paper with real difficult to read print on it. How many pages do you think you're going to get into that before your brain starts wandering? This is the weekend I'm supposed to mow the lawn. Oh my gosh, I spilled my coffee. We all do it. I do it sometimes too, a lot of the time. My brain will go down rabbit holes very, very easily. And so, same thing for VA raters. And that's not a slam on them. They're human. So what we do is we learn to write in a way that's more persuasive to a federal government bureaucrat, right? And I'm not slamming federal government bureaucrats, but there's a very specific way that they think, which is different than lawyers think. It's different than engineers think. It's different than policemen think. It's different than firemen thinking. Any position or profession that you are in has a completely different way of thinking than a federal government bureaucrat. And that's just the way it is. So we have to learn, how do you persuade a VA rater to grant your claim? And so you have to learn how to write that way. Fortunately, I've got a video up there. It's I think 25 or 30-minute video. I'm going to teach you how to get to the point, right? I'm going to give you 5 steps, P-O-I-N-T. Did I do that right? I think I did that backwards. In any event, I'm sitting here with my hands doing that. So in any event, get to the point. Learn the 5 steps of being more persuasive in your VA claim or appeal. Right? Simple things, like get rid of all the adverbs. Get rid of anything that ends in ly. It doesn't add any value, and all it does is, in most cases, become toxic. Slowly, quickly, whatever. Think of any ly word, and most times it's a charged word that suggests wrongdoing or inappropriateness based on the reader, particularly in VA claims. Go back and look at the last thing you sent to the VA. Look at how many ly words ending in ly, are in that writing. Cross them out and read it again and see how much different it reads. Just that one thing makes a huge difference. Changing the way, instead of writing big blocks of text, we talk about writing 3 or 4 things on a line. I talk about the basic rules being no more than 3 to 4 lines of text in a paragraph, no more than 2 or 3 sentences in that paragraph. Very, very, very short sentences that I would recommend being under 10 to 15 words. Things like that give your writing. Very simple to do. You don't have to be an English major. You don't have to be a good writer. I'm not the best writer, right? Someday I will show you my very first legal writing from law school and what the legal research and writing professor wrote on it. I really didn't think I was ever going to get a law degree. So I practiced, I got better. And these are the same things that I did and the same things that I do now in my legal writing. Now, I'm not perfect, but you won't be perfect either, and that's not the expectation. Right? The expectation is that we write more persuasively so that it's easier for a VA rater to grant our claim than it is for them to deny our claim. We could do that very simply by writing more persuasively. The last of the 5 things that you can do to change your experience, to have a better experience, to get faster results, and hopefully to get higher ratings out of the VA, is stop arguing with the VA and argue to them, right? That's a big difference. There's a big difference between arguing with somebody and arguing to them, right? So here's some indicators that you're arguing with the VA. You're yelling at them on the phone, right? You're not going to get anywhere. These folks have been yelled at more times than probably, most of us in the first 13 or 14 years of our lives got yelled at. They get yelled at by veterans, they get yelled at by their bosses, they get yelled at by their peers, and then they go home, just like us, they've got members of their family that yell at them. So they're really experienced dealing with yelling, and it's impenetrable. In fact, nowadays, if you start yelling at a VA employee, they're going to have authority to hang up the phone on you, and they're going to give you one quick warning, if any warning at all. So stop yelling at them. It doesn't do anything for you except get something off your chest. If you want to get something off your chest, go into another room, yell and scream and holler, and reduce your comments down to the basic bare bones things that you need to ask or you need to tell the VA in a particular phone call or in a particular face-to-face meeting, and leave the rest of it behind, right? Stop arguing with the VA. Think about using the words thank you more often. Right? And I'm not saying that you have to go out and kiss the VA's ass. I'm not saying that you have to go kiss any individual's butt. I'm not saying that you have to thank somebody for being a jerk. That's not what I'm saying at all. But recognize that when somebody does work for you, whether it's the expectation that they should have done that or not, it's very civil, very polite, and very encouraging to say the words thank you. Listen, I'm going to tell you a story. I was at a presentation that a criminal law association was doing several years ago on veterans benefits. And I was a speaker at this presentation, and I was talking about something and kind of got myself kind of tied in a knot about how something went, and was confused and asked if anybody from the audience knew the answer and would they come talk to me after the show. And it had to do with something within the Veterans Health Administration, the VHA. And so after my presentation, I came down off the stage, and an individual came up to me, and she was somebody that worked at a VHA facility, and she told me, she set me straight. She said, this is how it works, this is what you do, this is what has to happen, right? And so I did that in that particular case, and everything worked out great. And what I did is I sat down and I wrote a thank you note. Just 2 or 3 lines saying thank you, here's the impact that it had, I really appreciate you spending the time. I got a phone call from that VA employee in tears, because she said, this is the first time in 20 years working at the VA that somebody outside has come and said thank you. That's ridiculous. That is absolutely absurd. I don't care whether we like the Raiders' decisions. I don't care whether we like the DRO. I don't care if we like the BVA judge. I don't care what the deal is. If they do work, and if you wanted that work done, say thank you. It's polite and civil, right? Goes a long way. And when you spread that kind of positivity in your conversations, in your communications with the VA, it rubs off, right? That puts that person in a better mood. They feel better about their position. They feel better about their role. They feel better about the work that they're doing, and they're going to treat other people there nicely. So, the old saying about shit rolling downhill, if you stop the roll by being polite and saying thank you, it'll make a huge difference, right? And you don't have to acknowledge somebody with gratitude for something they didn't do. So I'm not telling you to be dishonest. Don't say thank you if somebody did anything, because they're going to perceive it as sarcasm, or it's going to come out from you as sarcasm. But recognize when somebody does something for you, whether they had to do it or not, and say thank you, right? Makes a huge difference. I will tell you that one thing alone has made a dramatic difference in my conversations with VA employees over the last 5 to 6 years. Dramatic. It's amazing how that one thing, and these are all basic Dale Carnegie things, by the way. So get the power, what is this? How to Win Friends and Influence People. I was thinking of Norman Peale's book. But get Dale Carnegie's classic book from the, I think it was 1930s that he wrote that, maybe the 1920s. So it's a little bit dated with some of the language. But get that book, How to Win Friends and Influence People. Read it. And if you follow those steps in the interactions you have with VA employees, you're going to have a much more positive experience. Let me see what I've got. I've got a checklist here, see if there's anything else. If the VA's decided to deny your claim, they're going to deny it. If they're not going to give you a favorable decision in the DRO conference, they're not going to give you a favorable decision. So that does not mean give up. What that means is get something else out of it. And I talk about this particularly in the context of the DRO conference. You've gotten a ratings decision. You've asked for a conference with a decision review officer, in the course of your appeal. You get this conversation. You know, because you've studied the claims file, you know that they're going to dig in their heels on this case. They're not going to grant. Try to get something out of it. There's two other things you can get out of it. You can get a CMP exam out of most DRO conferences, and a quick one, and you can get a statement of the case, right? So normally after a DRO conference, you're going to wait 2 years sometimes for a statement of the case, 2 years. And then that triggers your time to file a VA-9. You're going to wait 2 to 3 more years for it to get certified to the board. But if you know you're going to lose at a DRO conference, accept it. You don't have to agree with them. Say, I disagree with you. Could you do me a favor? Could you issue the statement of the case this week or the week after that so that I can turn around, file my VA-9? You'll go ahead and get the credit for or the points that you all get in your system. But the bottom line is you'll have the statement of the case 2 years sooner, right? So don't argue with them. Argue to them. And if you're going to lose the argument that you make to the VA, try to get something else out of it that will help to move your claim or your appeal along, right? And I have a lot of ideas on the blog about how to do that in different scenarios. I've got tips about how to do that. Some of the posts that I have in the show notes are going to share some information with you. But the bottom line is think outside the box a little bit. So, lastly, I'll get rid of that LY word, right? If I was writing, I would definitely drop that because it doesn't add any value. The final thing that I think that's a component of arguing to the VA is giving up on expecting actual assistance. And I tell folks this all the time. Don't confuse the duty to assist with actual assistance, right? And I don't mean that entirely tongue-in-cheek. I kind of mean that seriously. If you wait on a federal government bureaucracy that is struggling with backlogs in every facet of its operations to develop your claim, to help you find the evidence, to help you understand the claim, you're going to be waiting until the cows come home, and probably a lot longer because the cows come home really every night. So don't wait for assistance. Assist yourself. Take that duty to assist and say, I have a duty to assist myself in figuring out how to develop this claim myself, how to get the evidence, how to submit the evidence, how to make the argument in a more persuasive way, how to do it in a polite and civil way to the VA so that while I don't have to kiss their butt, at the same time I don't have to be a jerk causing delays. And I'm not saying that all veterans are, but there's a group, there's some really bad actors out there that make it really rough on the rest of us. But that said, don't hang around waiting on the duty to assist. Help yourself first. There's an old saying, and actually it doesn't come anywhere from the Bible. I don't know where the roots of it are, but God helps those who help themselves. Same thing could be said of the VA. And I'm not equating VA with a deity for sure. But I'm getting a little distracted because that reflection, I can see me in the background here. But in any event, I'm not confusing myself with, or confusing a VA with a deity. What I am saying is that the VA will help you if you help yourself. That's the only time you're going to get that assistance, is if you make it easier for them to grant the claim or to move that claim along down the appeals process than it is to deny the claim. Okay? So those are what I call the 5 reasons that the VA is screwing up your claim and how you have the power to fix them. They're not easy solutions. They're not solutions that are going to happen overnight. But if you focus on them, if you focus on sending the VA a needle, not a haystack, if you learn their language, if you get a copy of your C file, start reducing the amount of writing to be more persuasive in your presentations to the VA, and argue to the VA, not with the VA, you are going to have a better experience. You are going to likely have a faster experience, and you are hopefully going to get a better rating than you otherwise would have. So, in any event, that's the main topic for today. I know a lot of you will have questions. This is always a hot topic to talk about. I talk to a lot of groups about this topic when I do traveling and when I do speaking to groups. And there's a lot more that I could tell you about it, so shoot me your questions, and we'll see what we can get answered in the blog there. But I would like now to move on to the questions, because I have been talking for a very long time, and I'm worried that I'm going to go way over. But I'm trying to stall it for this sunset, so not quite dark yet, and I'm hoping it happens. But in any event. All right, so let's move into your questions. So the first question that we have, I'm going to get some water here. Hold on one second. The first question comes from Dave M. And this question is actually a few weeks old. So hopefully Dave's on the show. If not, hopefully he sees it when it is live or recorded version. Dave says, I injured my knee prior to my enlistment. I was cleared by the examining enlistment doctor who stated that my knees were fit for enlistment and were well healed. during my enlistment and after enlistment I developed problems with my knees. There's nothing in my military service records related to my knees, and the VA is denying my claim because there isn't any evidence. Should I use the presumption of soundness or the presumption of aggravation in my battle with the VA? So let's boil that question down a little bit because there's some jargon you all need to know. So when you go into military service, we all did it, and it was called by different names, but some of us went to a MEP station, Military Enlistment Processing Station. Other folks they have different names, but you basically go through a process of having the medical folks at the VA determine if you are fit for military service. A lot of times this consisted of you filling out that questionnaire with 75 questions. Have you ever had a headache? Have you ever had a thumb ache? Have you ever had a toe ache? Have you ever bled from the nose? Have you ever bled from the eye? It's got you remember those goofy questions that were so difficult and you think, you know what, my toe did hurt yesterday. Should I check yes or no? If I check yes, I'm not going to get in the military. You remember that? I'm joking about the toe piece of it, but you do remember that questionnaire, right? That's what most of us got, and that's the extent of the physical that most of us got when we went into military service, right? So the doctor or the nurse, or in some cases just a medic, would write down, things that you said onto that enlistment exam. You would go into service, you would come out, and the same thing happened at exit, your discharge physical, right? So when you do that entrance physical, when you're looking back on it in the course of your VA claim, a lot of times the VA is going to be looking at that too, because one of the things that they get from your military records, if it exists, is your discharge and your entrance exams. And they're going to look and they're going to see if anything is on that entrance exam in terms of notations of conditions. And if there is any way that they can connect it, they're going to come back with the most ridiculous thing. They're going to deny your claim because you have a pre-existing condition, right? How it works in reality, I'm going to tell you that. And that goes to this question that Dave asked about the presumptions of soundness and the presumptions of aggravation. You are presumed to have entered the military service in sound mind and body. That's the basic presumption, okay? It's called the presumption of soundness. Now, the VA can rebut that presumption, and there's a post that I'm going to share in the show notes that talks about what a legal presumption is, and it's pretty standard. When the law presumes something or a fact finder presumes a connection, the other side always gets a chance to rebut it. And in this case, the VA has to show two things if they are going to rebut the presumption of soundness. They have to show, first, clear and convincing evidence that a condition that was noted on your entrance exam, and I'm saying actual exam, not that piece of paper, we're going to talk about that. They have to show clear and convincing evidence that the condition that you have today is the same condition that existed prior to service. And then, even if they show that, they have to show clear and unmistakable evidence that military service did not aggravate that condition. Those are two of the highest legal burdens that are out there, clear and unmistakable evidence and clear and convincing evidence. There's a slight difference in terms of what they are, not much, split hairs over what they are, but the bottom line is they're the really high burdens. I don't think there's any, other than absolute certainty, I don't think that there's any legal burden that I'm aware of in the VA system that's higher. So when they have to make that rebuttal, it's really hard. It's really hard for them to show something pre-existed service if it's not noted in an entrance physical exam. So that's important. You want to look and see, did I just do that questionnaire and fill out the check your block thing, or did a doctor actually give me an exam and notate a medical condition on that entrance exam? If not, presumption of soundness applies unless the VA can rebut it, right? What if it's not noted, or what if it is noted on the exam? Then there is another presumption. If you come into military service with a condition noted on your physical, right, it's presumed to have been aggravated by military service if there's a worsening of the condition. So the presumption, the basic starting point, if it's noted, and if you have a condition today that's the same condition and it's worse, it's presumed to have been aggravated by your military service. Now, what did I say a moment ago? You can always rebut a legal presumption. And so the VA can come back, and there's certain things that they can show to rebut the presumption of aggravation. And I'm going to read this. You can find it at 38 U.S.C. 1153. But if it's noted, the presumption of aggravation works like this. A pre-existing injury or disease will be considered to have been aggravated by service where there is an increase in disability during service unless, and here's how they rebut it, there is a specific finding that the increase in disability is due to the natural progression of the disease. It's really hard. That's a really hard proof to do. They have to show specifically why the worsening of your condition is the result of the natural progression of the disease, not the stuff that you went through in the military. So think about it. Let's say you have a foot or an ankle or a knee condition, just like Dave did, that he mentioned his knee condition prior to enlistment. I find it difficult to imagine a scenario where military service of any kind, Marines, Army, Navy, maybe the Air Force, you guys didn't do a whole lot on your knees, right? That's a joke. I know you guys did a lot. In fact, we did a case for an Air Force veteran that has some really significant hip problems and knee problems because of the tight quarters that he was forced to work in on some of these aircraft. So I'm totally joking, making Air Force jokes there. Sorry about that. Send me your Army jokes and get even with me. But the point is that if you have a knee condition, if you have a foot condition, it's a really rare scenario that military service wouldn't aggravate it, and the VA has to specifically show that that condition would have gotten as bad as it was today, as it is today, because of the natural progression of the disease. And it's hard to do. So that's the presumption of aggravation. That's the presumption of soundness. The VA often confuses them. More times than I can count on one hand, the VA has been smacked down by the court for misinterpreting the two-step analysis it has to do in the presumption of soundness to overcome it. Right? They have to show those two things, and they almost always skip to the second thing, and they never hold themselves to the higher burden. So learn that. And the key question is, was the condition noted on an exam? So if you didn't get a physical exam, and the only thing that's in your records for your entrance physical is that questionnaire that all of us filled out that checks all the body parts as working or not working, if that's all there is, you didn't get an exam, it's not noted. So the VA is going to have to show clear and convincing evidence that a condition pre-existed service that is the same as the condition you have now. And they're not going to be able to do that. So that's the presumption of soundness, that's the presumption of aggravation. Really want to learn those if the VA is hitting you with a pre-existing condition denial, because there's no such thing, right? I did a post earlier this week. I'm going to have the links in the show note that we talk about the road to nowhere and how the VA uses the presumption of soundness as a trap to put your claim on a road to nowhere. So that's one of those areas where you can learn their jargon, learn how they speak and learn their language, and by learning what the presumptions mean and what presumption of soundness means and how to apply it, you can have a different experience with the VA, right? All right, so the second question comes from Brian L. And Brian says, how do I reopen a claim that was service-connected at 0% but now falls under the 30% rating? All right, so what Brian is really saying, and we're going to translate this for him, is Brian is saying, how do I get a higher rating if I think the VA was wrong? Right? So let's start out from the very beginning. What's a non-compensable rating? A non-compensable rating is a decision where the VA says something is service-connected, but it's not currently at any higher than a 0% rating level. It's not having enough of an impact that it can be rated on the schedule, or that it might qualify for an extra scheduler rating, right? And so what's the value? There's two major values in a non-compensable rating. There's actually some more I'm going to share. I'm going to post in the show notes. But one of them is that you are entitled to certain state-level benefits, or in some cases county or city-level benefits based on service connection. And sometimes those benefits from city, county, or the state don't necessarily require a specific percentage rating, right? So a 0% rating would get you some eligibility to certain benefits. If you have a business that contracts with the federal government, a 0% rating qualifies you in some cases. It's really complex. So this is not legal advice. I'm just telling you, look into this. But you can register as a service-connected, disabled, veteran-owned business. And there's certain advantages to that in the federal contracting process. Because the government has decided, we have told Congress as citizens that we want our government to have a special solicitude and solidarity with veterans and to give them advantages on their return to civilian life that other folks might not have. One of them is supposedly this non-adversarial claims process. Another one is the lowered burdens of proof. Another one is interpretation of laws should be to the most favorable interpretation to the veteran in certain situations. So there's all these, pro-veteran canons out there, and that's one of them. So there's where a non-compensable rating might be important. But in any event, if you have a non-compensable rating and you believe you're entitled to a 30%, do you file a claim to reopen? That's the question. Here's the deal. Claims to reopen really only need to be filed when there's been a denial of service connection on either the lack of nexus, lack of service connection, any one of the three elements, or a lack of eligibility, right? Because if you've gotten a decision granting service connection and the condition gets worse, you're going to file an increased compensation claim. All right, and these forms are all, it's the same form for this particular reopen claim or increased impairment rating claim is 21-526B, same claim form. But you're not going to file a claim to reopen a claim that's already been service connected. It doesn't make sense to do that. Just file a claim for increase, right? So the other thing that you want to look at is, in terms of making that decision, there's a third option. If the decision granting the non-compensable rating is less than a year old, meaning you've still got 1 year to file your notice of disagreement and appeal it, you wouldn't want to file either a claim for increase or a claim to reopen. In fact, you specifically wouldn't want to. Well, you might want to do a claim for increase. That gets a little tricky. Let me tell you that in a minute. But you're not going to want to file a claim to reopen. You're going to want to file a notice of disagreement and appeal it. That way you keep your original effective date. You might file a protective increased rating claim, but I'm not sure that that's necessary. It might slow things down. You have to look at that on a case-by-case basis. Sometimes it makes good sense to do that. Sometimes it doesn't. But the bottom line, it really depends on a lot of factors I'm not going to go into here. But in any event, that's the decision. If you don't believe you've gotten the right rating, should you file an appeal? Do you have time? If so, file the appeal. Is it already service connected? If yes, and it's gotten worse and it's outside the appeal time, file a claim for increase. If it's not service connected and it's gotten worse, you need to service connect it first before you can get the higher rating. So file a claim to reopen, right? And use 21-526B for claims for increase and claims to reopen. That way you have proof of the day that you actually filed both of those claims, right? Because the effective date for an increased rating claim can be up to a year prior to your original claim date if you could show the condition was worse a year ago. So you don't have to run into the VA and file an increased rating claim the minute it gets worse, right? Sometimes it takes time to be able to tell that it's gotten worse. Bottom line. So when you file a reopened claim, what are you going to file? You need new and material evidence. So here's a simple process to do it. If you're going to file a claim to reopen, look at the last ratings decision that denied service connection. Look at what elements were denied. Was it eligibility? Was it current diagnosis? Was it any of the three elements of service connection? Or was it the lack of nexus? Got a little bit tongue-tied there, sorry. But look at those elements and see what was denied. All right, write it down. And then go through your C file. You've gotten your C file, right? You've followed that step. You've gotten your C file. You're going to look through it, and you're going to see all the evidence that's in your C file that supports the evidence or supports the element on which the claim was denied, right? Then you're going to take a look at the new evidence that you have, and you're going to say, is it on this list? If it's not, it's new evidence, obviously. Then you're going to look and ask the question, is this new evidence material? In other words, would it help to adjudicate the missing element? All right, so here's an example. Let's say the VA denies your claim and they say that they're denying it because you don't have any proof that it's your condition, whatever it is related to your military service, right? So 2 years pass, you come back, you file a claim to reopen, and you've gotten some medical records from your doctor that talk about how bad your condition is today. Is that new? In all likelihood it is, because it's just issued today, but you're going to do that analysis of your C file to figure it out if it is new. And then you're going to ask, is it helpful to proving this element that's missing, the element of nexus or relationship to military service? And certainly, in some cases it could be, but in most cases that evidence is not going to be material. You'd probably have your claim to reopen denied, right? So, another example, let's go ahead and I'm going to give you, let me see, I've got it, yeah. The line of duty is a perfect example. Is you file a claim for service connection and they deny it on the basis of nexus. You had an injury in service that happened, you've talked about it, you've written your lay evidence, and they deny it for lack of proof that this injury ever occurred. All right, so say 2, 3, 4 years down the road, you file a claim to reopen, and you found the line of duty report that was done at the time of this injury to be able to show that it occurred in the line of duty, right? And that's very common on stateside, at stateside bases, and certainly in peacetime it was more common. I'm sure it's probably not happening as much in combat zones, but typically when a soldier has an injury that reaches certain degrees of severity, his chain of command has to do a line of duty investigation to determine if the military is in any way responsible or to determine if it's entirely your fault. I had one client many years ago, went swimming on a boat out on a lake, and he dove into the boat and didn't know how shallow it was, and so his head kind of impacted and crushed down his spine. He's paralyzed for the rest of his life. The line of duty investigation came in and said, okay, yeah, he was drinking a lot, but even if he wasn't drinking, there's no way he could have known how shallow the water was right there. And so it still would have happened if he dove in there sober or drunk, and they found that it occurred in the line of duty. So that's a perfect example right there. That evidence would be material to a finding of a denial of service connection years earlier, right? So that's what you want to look at in reopening a claim. Is the evidence new? And is it material to the element on which the prior decision denied? So if there's more than one element, you can have more than one piece of material evidence. All you need is one thing that's new and material to reopen that claim, right? All right, so bottom line, if you were denied service connection, file a claim to reopen. If you were challenging your rating and there's time to appeal, file a notice of disagreement. If your time has already passed and your condition has worsened, file a claim for increase. All right, next question. I have a CMP exam coming up. How do I get ready? I've heard I shouldn't shower or shave before the exam so that the examiner doesn't think I'm in real good shape. And I'm not going to, veterans asked to be anonymous. So let's talk about it. What is a compensation? What is a CMP exam? It's a compensation and pension exam, right? And so there's three kinds. Three situations where the VA is going to send you to a doctor to do this exam. The first situation is, we're not getting it. I'm going to have to turn off the lights and see if we can do this. Maybe I'll do it later, but I want to show you this one thing now that it's dark enough. But in any event, there are three types of compensation and pension exams. The first one is to diagnose a condition. In certain situations, the VA will need to diagnose what your condition is or to see if there is a diagnosis before they can adjudicate the claim. Another type is the nexus comp and pen, where the doctor is going to opine as to whether it's at least as likely as not that your condition was related to military service. And then the final type of exam is a rating exam. You can do these on disability benefits questionnaires and avoid the comp and pen, or sometimes the doctor in the CMP exam is going to use a DBQ or a disability benefit questionnaire. But the bottom line is those are the three types of compensation exam. And so I've got a really lengthy post online I'm going to share as a three-part series that goes through 10 things that will help you prepare for your compensation and pension exam. I'm not going to cover those things in detail here. I'm just going to hit the high notes. So the first thing, know what you're there for. When you're going into a comp and pen exam to get ready for it, know what you're there for and discuss only those issues. Okay, what does that mean? Are you there for a diagnostic exam? Are you there for a nexus exam? Are you there for a rating exam? And if you're there for a rating, you don't need to talk about nexus anymore, right? If you're there to get the condition diagnosed, you don't need to talk about nexus. Well, you might want to in that scenario, but generally speaking, talk about the issue that you're there for, right? It gets a little dangerous if you talk beyond that, because a lot of rating doctors are looking for reasons to deny the claim, because simply put, it's easier to deny most of the times. So know what the examiner is. The second thing that you want to do to prepare. And again, I've got 10 steps of preparation for a comp and pen exam on the blog. These are just the high notes. Know what these examiners are all about. We touched on this a little bit earlier. These examiners most of them have been doing this for a very long time. Some of them, it's all that they do. All right, so think about that. Think about going to medical school, becoming a doctor, and then your career. You go into the VA thinking you're going to be helping veterans and learning all this new medicine as it relates to things that happen in combat and recovery from combat, and instead the VA assigns you to do comp and pen exams. And so you sit there and you do the same paper reviews of files day in and day out. At some point, it happens to all of us. We get cynical about the process. Some people can push through the cynicism, others can't, right? So be aware that you might be going into some exam with an individual that's cynical about the process. And just know that, because you can read it a lot of times in their body language, and it'll tell you a lot about what your experience is going to be like. The other thing is, most of these comp and pen examiners, the ones that are employed by the VA certainly, are overworked. So you want to, again, remember that one thing that I told you is, again, with the examiner, don't give them the haystack. Give them a needle. Learn what you're there for. Talk about what you're there for. Answer the questions, and only the questions you're asked, right? You don't need to go beyond it. If somebody asks how you're doing, you don't need to launch into a 20-minute soliloquy on why the VA sucks, right? You're probably right, but it does no value, and that examiner is going to turn the button off and zone out, right? So I want you to be scrupulously honest about the severity of your condition. What do I mean by that? It cuts both ways, right? If your condition is not severe, you don't need to embellish it or play it up. You know, a lot of veterans get advice that says, don't shower, don't shave, go in kind of sloppy, don't, smell bad, and they'll feel bad for you and they'll grant your claim. That advice is about 40 years old and it's bullshit. And it's going to get you in trouble because these examiners have seen that situation time and time and time again, and they can spot the professional claimant, right? So be yourself. Be yourself. Be scrupulously honest about being yourself. If you wear jeans and a t-shirt when you go into the doctor and you're comfortable that way, wear that going into your CMP exam. If you love dressing up, and there's a couple of veterans, a couple of them were my clients that just love dressing up in very colorful, bright suits, and they wore that to their CMP exam, that's fine. If you've got an attorney, anything that I say here, you double check it with your attorney first because their advice trumps anything I'm saying here, okay? But the bottom line is, be scrupulously honest not only about how severe your condition is, but in many situations, a lot of veterans don't want to talk about the real severity because it might be embarrassing. It might suggest some sort of degree. It kind of, affects their pride a little bit sometimes, I think. I'm human, and in my own comp and pen exam, I was the same way. I noticed that the same things that I'm advising you guys to do in preparing for your comp and pen exams, I was doing in mine, right? So at some point, this is going to show up, and the VA is going to use this in my claim at some point. But anyway, the point is, be scrupulously honest. If your condition is really severe, explain it. Paint a picture. This is not the time to sugarcoat the severity. It's also not the time to embellish it, right? So if the doctor says, we're going to do this range of motion test, and he tells you to, move at your hips forward and then side laterally and twist and turn, this is not the time to push beyond the pain. This is where you go and you tell the doctor how far you've gone when you feel the pain, right? This is not the time to be the tough guy. You're not trying to get back on your units or getting off profile so you can get back with your unit. At this point, you're trying to show the rater the degree of severity, and you don't want to push past your limits just to show that you're tough. At the same point, you don't want to fake, oh, I can't turn this far if you can, because a lot of times, I'm going to tell you a great story. I did a deposition in an employment case, and my client went in for the deposition and was complaining about, how they didn't accommodate her disability because they didn't allow her to, they made her sit at this chair for more than, I think it was a half an hour or 35 minutes at a time, and she had to get up and move around. The other side's attorney, brilliant guy, and someday I'm going to get even with him for this, but he asked my client questions that took about 45 minutes. She never once stood up. She never once moved. And he pointed that out at the end of the deposition. That case was pretty much dead in the water at that point. But in any event, same thing applies to VA raters, right? Our comp and pen examiners, I'm sorry. They can see when you're faking it. So don't fake it. If you're doing this at the range of motion test, because I can only move this far to my left, but earlier you dropped your pen and you were able to turn all the way down and pick it up, somebody spots that you're not being incredibly honest, they're going to notice that, and it's going to impact the outcome. So be scrupulously honest. Don't downplay the severity, and don't upplay, if that's even a word, the severity, right? All right, so the other thing I recommend, you don't need to go in there and record the exam. You can if you want. I don't recommend it. It turns it into an adversarial situation, and there's no real need to. You are able to bring your spouse in or somebody that you trust if you need that. Certainly bring them in. You have to give permission. Some examiners may resist. I generally don't think it's a good idea to record these. What I suggest you do instead, because it's just as good legally, is when you get out of the exam, take a minute, take 15 minutes, sit down, and write down what happened. And I'm not talking, keep all the emotion out of it. We're talking just the facts, ma'am. And you're going to write down, the doctor asked question A, question B, question C. I answered, answer A, answer B, answer C. The doctor did this test. This is what happened. The doctor did this test. This is what happened. The doctor said this. I responded with this. No emotion, no argument, no explanation. Just write down the facts enough to jar your memory. If you really want to get, detailed about it, you can put it in an affidavit and get it notarized, and so that it's at the same date. That way you've got a contemporaneous record of what you say happened, and then it becomes his word against the doctor's word, or he said, she said, or he said kind of thing. But you don't need to record it if you just take down those notes and then later testify, I took these notes at the time of the exam. This is what he said. This is what I said. I don't think you need to record it. There are situations where your attorney may advise you to do that. There are certain situations where a VSO may advise you to do that. There's certain times where you may think you want to do that, and I'm encouraging you to follow their advice and follow your gut, but it's not necessary, and it kind of makes it a little bit confrontational. So, but again, follow your gut, trust your attorney, trust your VSO. Nothing I say overrides or trumps what they do. So, in any event, the other thing, it's easier to challenge a bad CMP exam on appeal, to challenge the methodology, to challenge the lack of testing, and to challenge the inadequacy of the conclusions than it is to fight with the doctor there and try to argue your case. They're not lawyers. They're not there making legal conclusions. They're making medical conclusions and medical decisions. It's one of those scenarios where you're not going to win an argument. You're not even going to know if your argument was successful until months later when the exam results come out. But the bottom line is you don't need to argue with the doctor. Don't argue with the doctor. Answer the facts, answer the questions that are asked, make sure you know what you're there for, right? Get a copy of your claims file so that if there's something that you don't know, don't go beyond your knowledge and don't pretend you know something that you don't, or don't guess at things. If you really don't know something, say it's in my claims file. If it is in your claims file, they've got to look at it anyway, all right? Okay, so that's today's show. Went really long. We're coming up on an hour and a half, so Facebook is probably going to be on the phone to me saying, get off this video, Chris, you're sucking down all our bandwidth. No, they're not. They love this stuff. But in any event, I'm going to go ahead and give you the coupons for this week. They're good through December 15th, 2016. That is next Thursday, I think. Yep. 15th. It also happens to be my birthday, so I'll be 45 years old next Thursday. I will not be in at work, by the way, on Monday. I will not be working on the blog, so if you have any questions, customer support, I'm going to try to get to it over the weekend a little bit, but I won't be back in until Tuesday. I'm not taking my birthday off. I'll be working my birthday. So in any event, these discounts you'll see recognizing and celebrating Chris's birthday. So if you want 20% off the regular price of the C-File webinar, all right, through December 15th, 2016, you get 20% off that regular price. Use the coupon code BIRTHDAY, all small letters, no quotes, birthday, and you'll get 20% off. If you're a premium blog member and you didn't get in on the free offer earlier, use your premium member 15% discount with that 20% discount, and you'll get 35% off, okay? So make sure you use those premium member discounts. The second one is 10% off of any subscription, monthly or annual. Coupon code is December, all small letters, no caps, no quotes, the word December. As I mentioned, it looks like the annual subscription price is going to go up after January 1st. I don't know how much. I'm going to talk to you about that later. But if you were thinking about getting a subscription and want to lock in the lower rate, now is probably the time to think about doing that. But in any event, guys, I had a great time with you. One of these days, I'm going to figure out how to take live questions in this, and we'll up the ante and have a really awesome presentation, as if 90 minutes of talking isn't awesome. But in any event, let me know your questions. veteranslawblog.org, Facebook Live, submit your question. Tell me what you want to learn in a podcast. Tell me about guests you want to see at veteranslawblog.org/podcast. Use those coupon codes. Have a great week, and we will see you next Friday on episode number 8 of the Veterans Law Blog Live Q&A. Take care. Have a great weekend.